Hello, and welcome to Bridgeford Trust Company's Delivering Direction and Control podcast series. Our podcast series is designed to educate, challenge, and inspire listeners while keeping you updated on developments regarding modern trust law and powerful planning opportunities available, all in an effort to deliver direction and control to clients and their advisors.
All right. Well, hello, everybody. This is David Bourne again here with another episode of our podcast series. I continue to be amazed at the quality of talent we were able to talk to and the thought leadership that we can support, particularly around modern trust law. And today is going to be a lot of fun. This gentleman I have known for a long time, Josh Bennett. He's an outstanding attorney based in Fort Lauderdale, and he was gracious with his time back when Bridgeford was very young and very tiny before I became the chair. But Josh and I had we connected on many different levels as kindred spirits. I don't know if you remember the first time, Josh, but I do. It was in the Bahamas, as I recall, and we ended up sitting right next to each other in our panels. But I've always heard your name from mutual friends, and always knew that you and I were Jersey boys. We just hadn't really met yet, although having grown up in South Jersey together. And I want you to talk a little bit about that and your connections to Atlantic City. But what strikes me as I think about the history of our friendship and collaboration is after years of hearing each other's name, we randomly run into each other. And then we ended up being on a panel discussion that we both didn't realize we were going to be on together. And then it occurred to me that this Josh Bennett isn't just a pretty face. You know, he actually knows what he's talking about. And he wrote a book that we're going to talk about asset protection, and he has an advanced tax degree, and his practice is really fascinating to me for a couple of different reasons, and I'll get into that. But we very quickly hit it off and realized that we had a lot of mutual friends in the industry, and also I think a mutual passion, Josh, around modern trust law and the kinds of things that you're going to talk about today that I'm talking about. Since in many ways why we started Bridgeford was because we loved asset protection and we loved directed trust and all the things that you can get just by suck and a proper trust jurisdiction. So when you and I, without much planning and preparation, ended up on that panel together, I think it was kind of a home run because we were saying the same thing. We were singing from the same hymnal as they were. So I am going to let you say hello. But first, I just want to be clear for our listeners where you're based. Josh's clients all over the world, which is very interesting. He speaks a couple different languages, but been in primarily Fort Lauderdale, right, Josh? For most
yeah.
Right. But he's somehow been able to manage to create these alliances from around the world, and I think that's a good place to begin. Josh has a particular knack, and for everybody listening, keep this in mind, for collaboration. And I've never seen him look at an attorney as competition, even other asset protection attorneys. And I've never heard a bad thing said about Josh Bennett. And that's not easy in the legal profession. I'm not going to make a joke about lawyers, but often lawyers forget the importance of collaborating with one another. And Josh just knows the right time to bring in another lawyer. The other lawyers know the exact right time to bring him in. And your vast network of attorneys in particular and planners around the world is pretty impressive. And I think that was very deliberate on your part. So maybe we begin there. I mean, why don't you start? Well, first talk a little bit about Atlantic City, then how you ended up in Lauderdale, because I know you spent some time in California too.
Well, first of all, David, thank you for having me on the podcast today. I hate to pat myself on the back, but I do consider that as one of my best qualities. I don't think there are too many people who have a bad thing to say about me. And even my ex-wife doesn't have really a bad thing to say about me.
So I don't know if you want to get carried away.
That's an essential compliment, I think, right?
No, but it's a gift though. And I'm not exaggerating or being funny. I think you should pat yourself on the back. I think I could have been and should have been better at that when I was a younger attorney and when I was still practicing. I think there's a competitive aspect, right, Josh? So not just being lawyers, but being in this industry. And it took me a while. And you kind of taught this to me by way of me watching you, that everybody's a friend and everybody's a resource and everybody can be there to help and bring you business. So yes, you've done a great job.
Thank you.
But let's go back to your origins in Jersey. And I understand, if I remember right, you have connections to the president, because didn't your dad sell a piece of property to Trump or something in Atlantic City or something?
Yeah. So I grew up in Margate, New Jersey. I'm currently now in Ventnor, New Jersey, right, which is the next shore point. As you know, you're a South Jersey guy from Linex. So those two towns, as you know, are right outside of Atlantic City. They share Absecon Island with Longport. I'm currently here now, like I said. And I grew up here, went to school here, graduated from Atlantic City High. And my dad was in the hotel business, and he had mom and pop motels and hotels over the years and casino gambling. The referendum passed in New Jersey for Atlantic City in 76. And he sold some of his properties to President Trump at the time, right? So it was such a visionary, came here and made a lot of great moves. Um,
So didn't one of the large casinos be built partially on one of your dad's properties or something? I can't remember. Was it the Taj or something? I thought there was one of them that actually.
Well, the Trump Plaza, which now they knocked down, and he
Yeah.
also owned the property adjacent to the Golden Nugget, the old Golden Nugget,
I
which
remember the
became
old
the
Golden Nugget.
Hilton, which now is vacant, right? Nobody's been in that
I
property.
remember all that very well. No, it's an interesting way to begin. So, how did you go from the son of a real estate person in Atlantic City to on the law school and to get into asset protection? Let's talk about that.
Well, I thought I was going to come back to Atlantic City and go into the hotel business, and then, like most Jewish moms, right? My mother said either become a doctor or a lawyer. I don't think I was a good enough student to become a doctor, so of course, I picked the legal route, and I went to law school down in Miami, Florida, and graduated there and got the LLM in tax. And then I clerked for the U.S. Tax Court for a year. And I came back down to Miami after a stint up in North Jersey with a large Philadelphia, New Jersey firm, Draper, Biddle, Shanley, Fisher, right? It's a Philadelphia, New Jersey firm. Came down to Miami. When did Flagler build that railroad? I'm trying to, I think I came down maybe 6 months or a year. No, that was back in the 20s. I came down in 1990.
Gotcha. Sorry, I wasn't tracking me with her for a second.
I came back in 1990, and I had my tax background, and I had a couple of years experience working in the tax department of major firms. And I got a job with a debtor's bankruptcy firm. It was a boutique debtor bankruptcy firm back in the day. And that was 1990 down in Miami. And they were basically setting up or putting high net worth debtors who would move to Florida from other states and using the liberal Florida exemptions, the homestead exemption, insurance products, annuities, and the like, right? And then we started working with a guy, God rest his soul, named Richard Cahan and Dennis Kleinfeld. Those three guys, we all kind of got our genesis started together, and we kind of helped create and advance asset protection trust planning. We started working with Cook Islands trust companies back in the early 90s. The one was TrustNet, which no longer is in business, right? But then we started setting up the offshore trust structures for wealthy debtors. And then the planning and the transfer planning was, I think, a lot more aggressive than it might be today, right? Especially vis-a-vis fraudulent conveyance concerns.
Sure.
But that's how we got our start.
Well, I just want to go back to your tax training, though, because I think I've come to believe that I think tax planning is just as much about asset protection as creditor protection too, right? Because you have to protect the assets from excessive taxation or maybe overzealous taxation, but also creditor claims. So I think it's interesting, the neat trajectory where you really were trained as a tax attorney, but then you kind of turned into more of an asset protection attorney. But again, I'd say they're kind of the same things. So I think of when you talk about offshore, I remember the movie The Firm and that whole thing about, money being moved offshore. And it's interesting to watch the evolution in the United States of what is an offshore asset protection trust and what isn't. But before we get there, you became pretty passionate about the topic and wrote a book. And I think you had just maybe had written it when we first met or you had copies with you. And I mean, the book is so unbelievably on point, and I still think current and relevant given what we're seeing with, I think, continued proliferation of the asset protection conversation. And I'm going to bring the book name up because I want our audiences to look for it. I mean, I see it's on your website, of course, but I mean, it's the ultimate guide to asset preservation. So what's interesting to me is you, I think, established a niche, it seems to me, before a lot of others did. So you saw well, first of all, you saw a need, obviously, but also you jumped right into it and then wrote this book. So to me, that's pretty innovative. And another thing I'm going to say about you that's different, and then because I want you to comment on how you decided to jump into that space. But Josh, you have a really an amazing ability to business develop, and sales is a dirty word, but let's just be honest. In all of our service industry activity, you have to make connections, you have to make yourself relevant, you have to be a problem solver, and you have to be a person, a good person. And in addition to your ability to collaborate, which has always been amazing to me, you've been able to find the niche. So the niche initially was offshore. So talk about that, and how what made you so passionate about it. I mean, in addition to just being a thought leadership tool, because to write a book takes some time, and you obviously researched that book and took a while to write it.
Well, thank you. Yeah, it did take some time. Usually, I use that book more as a marketing tool. It's geared towards clients. It's a book that was written for generating retail business. I have written other articles that are more technical, but this is a marketing tool, right? So I'm able to offer a free copy to clients to look at and learn more about domestic and foreign asset protection planning. Another point that you brought up is so true. My background is in tax and estate planning, right? And I don't see how anybody can become an asset protection planner, either domestic or setting up foreign asset protection trusts, without having that background. Because at the end of the day, it's still a trust, as recognized and formed under common law principles, and it needs to incorporate all of the current estate and gift tax minimizing techniques that a U.S. grantor, creator of a domestic trust would need to implement to achieve uh, succession planning and minimize taxes and plan for estate and gift transfer planning in an orderly fashion.
Which brings me to a quote I found in your book. The art is not in making money, but in keeping it, which sounds so simple, but I think we forget that. And I like that's how you let off on one of your chapters. So let's go back to offshore asset protection that became a very important industry. And then, though, you never, at least you can correct me, I never viewed you as pushing necessarily domestic over offshore, or offshore over domestic. It seemed that you had always had a very pragmatic way of approaching it, and I thank you for the opportunities we've had to work together. And I'm juxtaposing you against others in the industry who sort of come to the table and say, "This is it. This is all you're getting from me. This is all I'm doing." And if you want to go, you want something else from asset protection, you find another attorney. And you haven't approached it that way, and that's why I think your book, talking about both domestic and international, offshore asset protection back then, was kind of groundbreaking, because I remember the debates at Heckerling with certain attorneys that we're friends with. That it became a punch fest, intellectual punch fest over which one works the best. And I'm not sure it ever should have been framed that way. So talk about it from your perspective.
My perspective is I started working, as you know, with South Dakota, Delaware, and Nevada back in the infancy of these domestic asset protection trust statutes, right? I'm also a firm believer that in order to form a foreign asset protection trust, needs to be funded with certain assets, liquid assets, assets which can be transferred outside of the U.S., because that's your greatest protection, right? For example, you have a trustee in Nevis or the Cook Islands, and they're far away. The assets should be custodied outside of the U.S., and that gives probably the greatest protection, is to have the assets out of the U.S. and to have a trustee offshore in a jurisdiction that has excellent asset protection trust legislation. But certain assets obviously just cannot be used, I don't think, suitably fund a foreign trust. U.S. real property interests, assets which generate U.S. source income, certain types of assets. It's kind of analogous to fitting a square peg in a circular hole, right? The foreign trusts, I don't believe, should be used to transfer domestic situs assets, namely real estate, to a foreign trust for a myriad of problems, right? And the domestic asset protection trust legislation is really, really good. Okay. I think it's very good. It hasn't really been tested. There are only approximately 8 cases, and a lot of them aren't on point. 4 were uh, solved by the Alaska Supreme Court, and they really don't offer much guidance. But I think what you guys have, and I'm talking about all 21 states, South Dakota, Nevada, probably the leading jurisdictions and have the best legislation. But there's great legislation, but it's like the trust, and I'm speaking broadly, the trust companies have a great tool. And I think if you rely on the legislation with the right fact pattern, they work. But the problem is, you have basically a lot of these trust companies are owned by banks. You have the belt and suspenders approach, and they're not going to go the mile. I mean, over the years, I've had a couple of kind of scary fact patterns, and there was threat and litigation. I got a call immediately from the trustee or the representative of the trustee. What's going on with this case? Are we going to get sued? The Cook Islands trustees, I think, are a little, maybe because they're so far away, they're used to it, and there's a real settled body of law that protects them. But they look at it as an opportunity to generate more income too, to defend the trust. But I just think what needs to be done is the mindset for the domestic trusts to generate domestic asset protection trust business is to really say, hey, we're going to defend this and we're going to see what happens. And it might be a great test case, but I think that could be a source of business if handled properly, that really would generate a lot of income down the road. But that's my comment.
So, Josh, can't at least I don't think we can talk about asset protection without understanding and embracing sort of the negative connotation around it. And I'll come at it from this angle. I've been told by people in the industry that I should stop using the phrase asset protection because by definition, it seems to denote nefarious people who were trying to do bad things or who have done bad things. Don't agree with it, but I'm just saying that's what I've heard. More and more there's things being written about those of us who are passionate about privacy, which we're going to get to in a second, asset protection, and about how, the presumption is that the Josh Bennett's and the David Warrens of the world are collaborating to do bad things for bad people, which offends me. And I'm sure offends you too, because I don't believe that at all. And obviously I believe you were doing and I'm doing is extremely virtuous and these people have a right to it. But talk to me about that evolution, because, even when I was in Dublin and in parts of Europe in the last 2 or 3 years, private client attorneys were like in their own firm, separated off, almost like the black sheep of the legal community in Europe, which I didn't anticipate, particularly in Dublin. So talk to me about that. How have you run into that? How do you deal with that criticism?
Yeah, I mean, you look at the case law over the years in the asset protection trust field, and there's some egregious fact patterns. The Anderson case, the Lawrence case, the Schwartzbaum case, egregious fact patterns where you had some really bad players generate income illegally and transfer assets offshore and not respect the trust structure and commit fraudulent conveyances, right, with the intent to avoid, hinder, delay a present creditor or an ascertainable future creditor. I'm conservative in my approach, right? I mean, I do it when a client comes to see us for asset protection, transfer planning. We really do a thorough intake, kind of like when a criminal lawyer maybe takes on a representation for a defendant. We make sure that we're very comfortable with the fact pattern, and we're not going to recommend to the client or especially to our trust partner a fact pattern that's going to blow up in everybody's face or won't work, right? So I think if you're conservative enough in the type of business that you take on, then I think you're going to have a pretty good shot that the trust will stand up and the assets won't be used to satisfy an individual's judgment.
Right. Well, and I just going to take that even a step further. I mean, fraudulent conveyance provisions are there for a reason. KYC, which is very stringent in South Dakota, as you know, is there for a reason. And of course, David Warren and Josh Bennett don't want to do anything to end up on the front page of the New York Times. But I do believe, and then this is a good transition to privacy, that these families are entitled to a degree of asset protection. And these business owners in particular, doctors in particular, and there's a way to do it without dealing with the bad actors. But recently, in light of the attempt to put the Corporate Transparency Act in place, the advent of CRS around the world, there's just been this, as you well know, this push for transparency that you've watched. We've been in the industry longer than me. It continues to be amazing to me, and I think Corporate Transparency Act might become. I don't think it's dead. I think it might come up again in some form or fashion in the United States. So talk to me about that, because I think that, we all live through Switzerland and the secrecy versus privacy thing. But I think privacy is goes in conjunction, has to be talked about in the same sentence as asset protection. But tell me, how do you approach that?
I think in theory, privacy is great, right? But I never will set up a structure for someone expecting that the attorney-client privilege is going to hold up and not be pierced, or the documents won't be pierced. And first of all, we meet with the accountant and we make sure that the client reports his worldwide income if he does have investments or assets offshore, not only paying income tax on any foreign source income generated, but also filing the myriad of foreign holdings forms that the IRS requires, right? So we make sure they're compliant. Second, any type of asset protection trust plan isn't done under a shroud of secrecy, right? I mean, we basically establish the trust and base it on agreed set of trust asset protection laws like the Cook Islands or South Dakota or Nevada or Nevis. The trust is also an estate and gift succession plan, which incorporates all the current estate and gift transfer tax savings techniques in the document, because we know down the road if there's an issue and someone gets a judgment against our grantor, against the transferor or the trust, we know that everything's going to be discoverable. We know questions are going to be asked, and fine. We don't base the asset protection or rely on the judgment creditor's attorney not reviewing every document or looking at all the investments and bank statements or tax returns. We basically rely on a well-crafted trust document, which is tried and true, and tax returns that are compliant, and say, here, go ahead, knock yourself out. Good luck getting at it and piercing the trust, but go ahead, knock yourself out. So the privacy, the attorney-client privilege, I think, like you said with CRS, in fact, that's I really think that's been eroded so severely. I kind of, as from an asset protection planning standpoint, I'm not relying on that at all.
Oh, that's interesting. Well, let me flip the conversation around a little bit and tell me how you think about this. So, particularly in the last year or so, the stuff I'm reading and preparing for various presentations or whatever, I've become pretty fascinated by the things we needed to read in law school, these seminal trust, Scott's on trust and all these, big long compendiums that were used to teach us how trust work and wills work. And one of the things that has stood out for me is how each of those seminal writings have some sort of semblance or reference to a fiduciary duty to protect the assets, a trustee having a fiduciary duty to protect the assets. So I've taken up this argument that is a little controversial sometimes, depending on who I'm talking to, is, hey, not only what we doing virtuous and we're not aiding and abetting fraud and all of the things, but it's also an obligation we have under, there might not yet be a case on point. But the question is, if a trustee in New Jersey knows or should know that putting that trust in Delaware, South Dakota, or Nevada is going to better protect it from a taxation perspective, more importantly, as protection, because there's people involved in statutes you just mentioned, and they don't do it, how is that on the breach of their fiduciary duty? It's a conflict of interest, because they're not going to lose business and take business away from themselves and place it with an independent trust company like Bridgeford in South Dakota. So I've kind of turned the argument around a little bit and said, well, not only are we proud of what we're doing, and I think the industry is virtuous, but I also think it could be argued that there's a fiduciary duty to do it on not just trustees, but on lawyers, CPAs. And if we're not careful, this could turn into a malpractice issue. If at least the file isn't noted that they had the conversation about a domestic asset protection statute in Delaware or Nevada, wherever, where these people could have gotten protection from a subsequent divorce or all the things. So comment on that. How have you seen that?
Well, that's a good question. Okay, so the obligation, for example, I practice in Florida, right? And if the client, we have a like you said, a worldwide practice. We have clients in multiple jurisdictions, internationally and domestic. But if a client resides in Florida, I would never recommend uh, 9 out of 10 times that he set up a Florida trust. I'd always recommend a trust in one of the 21 asset protection trust jurisdictions. Okay.
Mhm.
Even if a client comes to me from a state like Missouri or Arkansas or New Hampshire that has asset protection trust legislation, I think I have a duty as a professional to say, hey, your state has domestic asset protection trust legislation, but there's states such as South Dakota and Nevada which have better asset protection trust legislation. And even though historically these trusts have been challenged because if you have a client, let's say from one state, and then they set up or establish a trust in another, like South Dakota, right? It might be a little easier for a judgment creditor to attack that transfer rather than if the client was from South Dakota and availed himself of
Yep.
the South Dakota trust legislation. But everything that's coming out, especially in the conflicts of laws cases, or the conflict of law amendments, and also commentaries, it's if you're in a state that has domestic asset protection trust legislation, you can go to any other state because it's more it, it it's prudent planning to use another asset protection trust statute if it's better.
Yeah.
It's not gonna really create a problem as long as you're from a state, even if it doesn't have asset protection trust legislation, if they still recognize certain types of quasi asset protection trust, right? When it comes to certain type of estate and gift tax planning techniques where they provide some asset protection, it's kind of hard for a judgment creditor to argue that, well, he's from state A and he set up this trust in state
Right.
B.
Right.
There's no reason they should avail. Everybody should avail themselves of the best
Hey,
legislation.
no, I agree with you completely. No, I think that's another way of saying what I've been reading, and I completely agree. Well, that's a good segue into. I know you follow this very carefully. This is your art and your craft, and you want to give the best advice. So, what developments do you want to share with us and those listening and watching? Because this does evolve, and like I said, when I first jumped into it after starting Bridgeford, I think the narrative has changed a bit in terms of what is the best jurisdiction, what is the offshore, onshore, like we said. So, what are you seeing? What's your research showing you now with regard to asset protection?
With the what? I'm sorry.
With regard to asset protection and all the things. I mean, it's evolving, right? So tell me, what are you seeing? What's the future hold?
I think there's been a couple of cases which have come out. Like we said, it's not really settled, the domestic asset protection trust legislation, because there's only been 8 cases, right? And they really haven't addressed the actual asset protection trust validity. But I think it's going to get much easier to do domestic asset protection planning because look, now you have Arkansas, which just adopted asset protection trust legislation. So now we're up to 21 states. So that's almost half the amount of
Yeah.
states now that have asset protection trust legislation, right? And that means I think there's really people are starting to understand, hey, this is good legislation and we need to take advantage of it. But I think there just needs to be more fact patterns and more case law out there, right, to substantiate the great law. But due to fraudulent conveyance concerns, you have to really carefully make sure that the client's not a bad character, right? That there's no judgment against him, or if something's pending, it's not 100% ascertainable, right? You really have to do your due diligence and research so that it's not avoidable transfer.
Well, let's stay on that point because I mean, most of what I did before I got into the trust space, I was a litigator. I did some fiduciary litigation, and one of the things that sometimes I forget about, but I remind myself when I'm in conversations is, okay, so maybe there's not a lot of case law, but isn't it though working the way we want it? Or there's probably not a lot of case law because a plaintiff's attorney may see there's a trust and says, I don't want it. I'm not going to charge the client $1 million to try to pierce that thing. Or forces a settlement, I guess is what I'm saying, because it exists. And so most of the work I did on the litigation side was defense. We defended a lot of doctors and hospitals and whatever. But I have to believe that's, I mean, it's working in so much as the way it's supposed to work. It's it's a deterrent for fraud, frivolous lawsuits and frivolous claims. I would imagine, right? I mean, there's a lot of unscrupulous plaintiffs attorneys, and I'm sorry anybody listening is offended by that, but I saw it firsthand where they, somebody fell off a sidewalk and they're suing for $1 million, right? I mean, it has become crazy in this country. So comment on that, because I think we're never going to be able to measure just how much of a deterrent these are, and it's keeping people out of the court system and forcing the settlement of cases for more reasonable dollars. Josh, I guess is my point.
Yeah, and I'd say over the past 3 to 5 years, our clients have become younger, smart young business people. A lot of them have made their money in internet-related business and tech and what have you, right? And they look at it like you said. They look at, let's set up a South Dakota trust or a Nevada trust to be able to get the asset protection. We have no current claim. We're single. It's going to be great to deter a future claimant. It's also going to be great if I get married, because South Dakota, like many of the states that have the legislation, have strong laws in effect when it comes to protecting the trust assets from future spouses, future child support claims, future priority creditors, right? So it's an excellent planning tool, and there's really no better prenuptial agreement from a creditor standpoint and a future marriage standpoint than a South Dakota trust.
Mm-hmm. Yep. Oh, I agree. I years ago I wrote on that. I think you said it perfectly. Well, I want to make sure we are clear with our listeners and viewers too, because the presumption, at least when I was in law school, I'm sure you too, none of this really existed, and there was this big bad concept called an irrevocable trust that everybody was afraid of, because it was rigid, expensive, hard to deal with. You lost all direction and control. But you write about a concept that I love, and is really the foundation of everything we've built at Bridgeford, called directed trust, which is still finally getting attention and favor after all these years. I mean, you and I have been talking about it since the beginning, but now states like Pennsylvania and California are trying to come up with a version of in Florida, come up with a version of a directed trust, which I still think they all pale in comparison to the top tier trust jurisdictions. But explain that to the audience. A lot of folks might not realize, look, you get this asset protection, of course, the tax play, but you're also not giving up all the direction and control like you used to either, which I think that's the big game changer too.
No, yeah, no, for sure. So when you set up a self-settled, we set up for a client a self-settled trust, right? Which means that the client is the grantor, the creator of the trust, and also primary beneficiary, right? In most states, there is no asset protection when it comes to a future creditor gaining access to a self-settled trust assets to satisfy the grantor's judgment, right? Now, and that's been the law for years. Now you have a state like South Dakota, which has great asset protection trust legislation. And what that asset protection trust legislation basically is contrary to the self-settled trust principles found in most states, saying, no, the trust is irrevocable for South Dakota creditor purposes, right? And it's directed, which really provides the grantor with a level of comfort, because if someone gets a judgment against him, the trust is irrevocable, but also a self-settled grantor trust, right? But he doesn't have to worry about the trustee unilaterally making all the decisions. Obviously, if someone gets a judgment against him, he can't make all the decisions. I don't care how good the law is, because it's going to be easy for a judgment creditor to go in and say, Joe Grantor is the alter ego of the trust, and he's making all the decisions, and I'm going to satisfy the judgment creditor's judgment against the grantor with the trust assets. But what South Dakota law does, or Nevada law, is they allow for the trust to be directed. So the client, the grantor, can appoint an independent distribution advisor to direct and instruct Bridgeford Trust to make the distributions to the beneficiary. They can appoint an investment advisor to the trust, which the client can be the investment advisor.
Yeah, I love that.
And also
Why don't you
protect-
linger on that for a minute? Why don't you define that more? Because I think that is one of the most powerful aspects of the statutes that are written correctly. Explain what you just said.
About the investment advisor?
Yeah, and who can serve in that role? Because I think that's very powerful.
Well, the investment advisor can be the client, because really the investment advisor
amazing.
can instruct the trustee to make whatever investment he sees fit, right? So it's good for the client because he's basically making the investment decisions. And it's also good for the trust company because if the client makes a bad investment decision, the liability isn't on the trustee, and it shouldn't be, right? But the client can never be the distribution advisor unless he's part of a committee and can serve on a committee of distribution advisors. So instead of one, you have 3 or 4, and he can be in the minority. But just having the client on that committee with people that he appoints goes a long way when the committee goes to make a decision about a distribution, right?
No, I agree. And I think it's such a game changer. Also, the idea of a trust protector. I mean, for the audience and those paying attention, I mean, we're talking about the ability to bring asset protection and privacy without giving up direction control. And I love talking about the trust protector in conjunction with the structure of the directed trust. And I know you use them heavily too, right, Josh? So we talk, if you don't mind explaining how does that offer even more ability to maintain direction control?
The trustee protector?
Yeah.
Yeah. Well, the trustee protector is very common under British trust law, right? But not in the U.S. A lot of people still, it's gaining popularity, but a lot of people in the U.S. don't really understand the role of the protector.
Right.
The protector makes a lot of major decisions, right, which affect the trust vis-a-vis the trustee, that the client won't be in a position to do if someone gets a judgment against him, right? Replace the trustee, add additional beneficiaries.
Change jurisdiction. Yeah.
Yeah, and it's a great tool. It could be a committee, it could be a company, a South Dakota LLC that instructs a special purpose entity, which serves as the protector committee, which instructs the trustee. There's a lot of different variations, right? Depending on what the client's needs and objectives.
Well, isn't it amazing how much it's changed? I mean, I always say this, and we have, I don't know, almost 60 episodes now, and I love these conversations because I'm reminded, I didn't like this stuff in law school, Josh. Like I wasn't a tax guy. I always wanted to do litigation, and my trusts and estates classes I thought were boring and stodgy and not interesting. And then all these years later, it is very dynamic and it's very interesting what you can do for families that didn't exist when you and I were both in law school. And I still am amazed at how many attorneys, and I'm not being critical of our fellow attorneys, but how many attorneys yet are not still working with the full capability of what is modern trust law right now. And I see it a lot, in particular in the West Coast. And I think it makes your book even more important. And for those, again, it's on Josh's website. We do a lot of writing on it. I mean, this isn't sales. This is thought leadership stuff. If people aren't familiar with how a directed trust works, you need to. If people don't think that they need to talk to their clients about asset protection, you probably should. I mean, these are the things, Josh, that I'm still hearing that are I almost argue with people in certain parts of the country. Like they tell me I'm out of my mind, and I'm like, well, no. Going back to, I think you have a fiduciary duty to do this. You might get hit with malpractice for not suggesting it one day. So I think we should go to a CLE here and learn how some of this stuff works.
No, great. It's the role of the advisor, the attorney, but I think I think a lot of it really should come initially because he has the relationship with the client 9 out of 10 times is the accountant or the RIA, right? The RIA should be able to see, hey, South Dakota has great legislation. This is something that you should do. And unlike a foreign trust, the RIA isn't going to lose the business because if you set up a Cook Islands trust for a client and the client comes from the registered investment advisor, 99 out of 100 times he's going to lose the business because his broker dealer won't allow for a WIMY foreign trust, foreign intermediary with a WI beneficiary to custody or invest those assets.
Yep. So it's a threat. Yeah, no, I get it. That's a very good point. That's a great point. Well, Josh, I mean, as we kind of wind down, I need to congratulate you again. I mean, wasn't just hyperbole. I've been paying close attention to you over the years. I mean, we've become good friends, and I value that side of things very much. But I mean, watching you get along with everybody in the sandbox is very, very, very unusual. And I think you are proud of it. You should be very proud of it. I wish more of us were this way. I think that there should be a lot more collegiality. I mean, although I don't practice law anymore, there's not enough collaboration and congeniality, and you have just figured out how to do it in such an amazing way. And it's been a bit of an inspiration to me, even with regard to other trust companies. I think I've learned that it's probably better to get along than it is to not get along, because we can learn from each other, and it's an interesting dynamic industry, especially now with all the consolidation. So is there anything else you want to share with the audience before we let you get back to the cold weather and southern New Jersey?
Well, thank you again for the opportunity. If anybody's interested, I'd love to send them. They could reach out to me directly, and I'd send them a complimentary copy of my asset preservation planning book. Right, they can call me directly, and I'll send them one. And there's also a digital copy on my website, joshbennett.com, too, that they can download.
Yeah, which will be attached to this. And so I highly recommend anybody who's interested in any of these topics to look at it. It's written so well, too, because it's not a law review article on purpose. And that's another thing, Josh, that I like the way you've written, because people don't like law review articles. I hated writing law review articles. So you made it interesting in the way you wrote the book. And it's amazing to me all these years later that it's still relevant. So I can't thank you enough for the friendship and the patience you've had with me over the years, and you were around and supporting us when we were tiny in the industry, and you continue to be a great friend, and we continue to trust you completely. You're highly ethical, and I say that on purpose as we end, because if there's a presumption that asset protection attorneys somehow are swarmy, nefarious people, that's not the case with Josh Bennett. And so for anybody interested in a topic, or has a family, or has their own concerns about asset protection, highly recommend you talk to Josh. So Josh, thanks again for the friendship and all the collaboration, and I look forward to a lot more of that to come.
Thank you. So do I. Thank you, David.
Thanks again for listening to Bridgeford Trust Company's Delivering Direction and Control podcast series. Be sure to subscribe to our podcast to keep posted on when new episodes are added. And for more information, you can visit us online at bridgefordtrust.com.